back to Consider This. Melisa and Sharaad here with you tonight, and we're speaking to Nizam Bashir, lawyer representing the parents and the child in the bin Abdullah case. As you may have heard, the federal court had a majority ruling last week. Now, 3 of the 7 judges on the federal court panel for this case dissented, and the 3 dissenting judges gave 2 separate judgments. I'm wondering, Nizam, if that is first of all, if that's common that the 3 dissenting judges gave 2 separate judgments, and what were in these dissenting judgments that you found particularly interesting?
Sure. I don't think it's particularly common, especially to find a dissenting judgment written or 2 separate dissenting judgments. I think that's quite uncommon. But by the same token, I can understand why it happened, because I'm sure the facts that's involved in the matter that was at the federal court was compelling enough that it must have caused them to search their conscience and grapple with the issues that was raised for them to decide on. I mean, let's look firstly at perhaps the what I found most compelling in Justice David Wong's minority dissenting judgment. Yeah. He focused on the right to equality, and also the fact that when in birth certificates, one of the complaints that we made was in the birth certificates, aside from the naming aspect that was argued in the federal court, there's a column at the bottom where there's a remark column where the registrar made a notation of Section 13 application. So that Section 13 application effectively informs the world that the child is illegitimate. And we, when we complained about that to the court, we basically said that, look, you shouldn't be telling everyone, all the sundry, that this child is illegitimate. Now, of course, there may be some stakeholders who may have some basis to know that the child is illegitimate. For example, the Sharia courts may want to know that the child is legitimate for purposes of marriage, etc. But there are ways to deal with that, because when you apply for permission to marry in the Sharia courts, there is a form. You've got to supply the marriage certificates of your parents, etc. And from there, you can tell very quickly whether the child is legitimate or otherwise. And there are consequences if the child is illegitimate. But for non-Sharia purposes, I certainly don't see any reason why that sort of information should be shared with the world. And that was the very same approach that Justice David Wong adopted in his minority judgment. And he basically said, his lordship basically said that, look, you can't share that information to all the sundry. For example, when you apply for your driving license, what business is it for the road transport department to know that the child is legitimate? There's no purpose.
There's a right to confidentiality too, isn't there?
Exactly. Yeah. So that's perhaps the principal ground that Justice David relied upon. There's also Justice Nalini's dissenting judgment. She looked at whether whether it was appropriate to deny the Muslim community from the right to rely on Section 13A of the Birth Deaths Registration Act, because the majority judgment took the view that surnames do not subsist for the Malay Muslim community, and therefore you can't avail yourselves of the mechanism afforded by Section 13A. She adopted a different view and said that, look, there's something called a patronymic surname, a surname that doesn't pass on generationally, but just passes on from one father to the next. So when for Malay Muslim children, basically, the patronymic surname operates in such a way that you will have a bin of the father's name, and so on and so forth, even as you go down the generations. Yeah, and she took the view, because there is this concept of patronymic surnames, Section 13A can be relied upon to afford relief for Malay Muslim illegitimate children to essentially apply to the registrar and enable the child to be named with the bin of the father's name. Yeah, and certainly, as if we talk about all the other issues, for example, right to identity, best interest of the child, these are all very important values and very important concepts for a child growing up in a family unit.
Can I ask a very simple question? I mean, why wasn't this fought in the Sharia courts?
Well, we were just looking at the application of the Birth Deaths Registration Act, which is a civil act, and whether the registrar exercise his powers of that civil legislation in an appropriate manner. There is no Islamic law question as such in terms of how he should exercise his power, because if you look at Section 13A, it's very clear as to what he's supposed to do. It just requires a joint application by the mother and father. As long as the father says, I'm prepared to give my name, that's the end of the matter.
Right. And where does the case go from here, Nizam? What's next after the federal court?
Well, as I mentioned earlier, you see, in the course of judgment being delivered, one of the clarifications that the AG's chamber sought was whether they could maintain the remark, Section 13, in the remark column of the birth certificate. We found it quite troubling, certainly, that the court took the position that it was lawful for the registrar to make that remark. And certainly we intend to revisit that by way of a suitable review application, because we certainly can't see the basis or source of that power in the Act itself. So we'd like to know from the court, please clarify and let us know exactly where that basis to maintain the remark is coming from. That's I suppose, one starting point in terms of the review application. There's of course some other arguments that we intend to ventilate, but I think it's also worthwhile to note, as I said, Tuanku Johor has made a commandment as to the effect of the fatwa, and I think it's worthwhile to perhaps quote him exactly on this, in the sense that he said whatever that the fatwa may be previously, it cannot be enforced sehingga menzalimi anak tidak sataraf sekaligus mengaibkan mereka pada masa depan. So there is, I think, His Majesty was very concerned about the future of the child, the best interest of the child, and I think then there may be some avenue even in terms of exploring how that can impact on future applications to the NRD.
Finally, we have what your clients or people like your clients do. You said they send their kids to Chinese schools, they might not have a second child, so on and so forth. What are the practical implications of this ruling for them?
I suppose we are still trying to work out exactly the full ramifications of the judgment. But as I said, there were two questions of law that was answered by the federal court, and effectively the score was 1-1. So I don't think there was a real clear winner in that sense. But moving forward for parents in this sort of a position, grappling with this issue, I think they shouldn't basically give up. I think we are on the right side of history. As I keep saying, the children are innocent. There's a beautiful qasidah in front of a maqam of this famous poet in Turkey, Rumi, and it basically says, "Come, yeah. Whatever you have done, this isn't a caravan of despair." I don't think our courts is a caravan of despair, and I think we should certainly strive to push this issue still further. I certainly think there's many things that can still be argued, and God willing, we'll get there.
Well
Great,
said.
wonderful.
Thank you so much for being on the show, Nizam. It's been a pleasure speaking with you today.
Thank you.
I'm Melisa, Idris, with me Sharaad, Kuttan. That's all the time we have on Consider This tonight. Thank you for watching, and good night.